You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News editor-at-large Bill Rochelle. As always, you can check out his daily bankruptcy column, available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Two major items of note today. We're going to talk about two enormously complicated cases that have been going on for quite some time. The first one is Mexican glassmaker Vitro. What's the latest on that one?
Well, I'll tell you what. Do you remember that wonderful scene from Blazing Saddles where Cleavon Little is playing the black sheriff in an otherwise racist town, and he takes himself hostage and points his own gun at his own head? Well, I hate to say so, but I think that's what's going on with Vitro.
How so?
Well, here's the story. Vitro is a big Mexican glassmaker, very large company. It is in reorganization in Mexico, in a court in Mexico. It issued bonds in the U.S. And these bonds said that they are governed entirely, top to bottom, by U.S. law. And nothing that can happen under Mexican law can affect these bonds. And importantly, these bonds were guaranteed by essentially all of Vitro's operating companies. The parent is the only company in bankruptcy in Mexico. For the most part, the operating companies are not. The Vitro parent has a reorganization plan pending where, if it succeeds under Mexican law, the debt owing to bondholders will be chopped in half. And there are about $1.2 billion of bonds that have been in default for more than 2 years. As you can imagine, the bondholders went nuts about this because what bothers them is how the shareholders in Mexico will retain their ownership while they may get new paper that's only worth maybe half. So they sue in New York State Supreme Court for a declaration that you can't do this in Mexico because it violates the terms of the indenture, which says, as I mentioned a minute ago, that Mexican law can't affect the operating company's obligations to pay the bonds in full. Keep in mind, of course, as I said, that the operating companies are not in bankruptcy anywhere, and they're using the parent to chop down on the debt. Now, I don't know how this is going to come out. The New York State judge has said a couple of times in the last couple of weeks that you can't use Mexican law to affect the guarantee that is owing to the bondholders. But still, it's unclear whether Vitro will go ahead with what it's planning in the Mexican market. Now, this could have several effects. Number one, at the end of the day, it is not clear that the U.S. courts would enforce a Mexican court reorganization. And that would be like a train wreck, because it would be terrible if the U.S. courts were to say, we're not going to respect, for one reason or another, what Mexican courts do with their own companies. And in addition, if Vitro gets away with it, it's going to make issuing bonds by Mexican companies in the U.S. market much more difficult. Vitro may succeed, but in the process, they may shoot other Mexican companies in the head. That's why I made the allusion. Or
bond issuers from other countries, not necessarily from Mexico,
that's entirely correct. And that's why I said it was like Cleavon Little, where he threatened to shoot himself, because that's really what it amounts to. It would be good for this one company, Vitro, and its shareholders, but may not be so good for Mexico or for companies from other developing areas trying to sell bonds in the U.S. market.
Bill, this is a big issue. Any idea on how the New York judge is going to handle this case?
Well, the New York judge has so far come down squarely on the side of the bondholders, saying you can't do it. Whether Vitro tries to go ahead in Mexico, I don't know. There is also a role that will be played by a U.S. bankruptcy judge in Texas, and that is also as yet undecided.
And last week we thought we were finally finished with the Washington Mutual bankruptcy. Turns out we're not. We have a major opinion coming out from Judge Mary Walrath dealing with mortgage-backed securities. What's the takeaway from this?
Well, what we have here is a little old bankruptcy judge who issues a very big opinion on mortgage-backed securities and on the question of who is a control person that can be responsible. Keep in mind that the WaMu parent did not issue a whole mess of mortgage-backed securities, but the bankruptcy judge wrote a reasoned opinion where she said that nonetheless the WaMu holding company is liable. And she did something else too that is really going to bother bankruptcy folks. She said that a subordination provision in the bankruptcy code for securities lawsuits does not apply to this situation. And I think on both of these scores, number one, we're going to have issuers of MBS securities are not going to like the MBS part of the decision. And a lot of bankruptcy folks are not going to like the subordination part of it. This is a really terribly important decision that I think is going to eventually go up on appeal unless they settle. And if it does settle, then this case is going to stay on the books as it is.
Any ideas on how it would be treated on appeal at the next level?
Tell you what, Lee, take a coin out of your pocket, flip it,
really,
and you'll have the answer.
All right, well, that's one to watch. We'll be talking about WaMu even going into the future. This case just won't die. Bill, thank you. That's Bloomberg News columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just discussed, go check out the Bloomberg Law Bankruptcy Law Report as well as Bill's column. Both are available on BloombergLaw.com and also the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.